So the next seminar that we have up is Hodgepodge of Factors That Can Influence the Payment of No-Fault Benefits, and presenting that is going to be Suzanne Kavas. So I will turn it over to Suzanne.
Good morning. The most difficult part of this presentation was deciding between hodgepodge, smorgasbord, potpourri, you know, the things that keep you up at night. But my discussion will be truly a hodgepodge of just the different issues that have come up over the years in my practice that can influence the payment of no-fault benefits. And they truly are a hodgepodge. And some of these, for as many years as I've been practicing, it's amazing how little things will come up that I had no idea. Even reviewing the rules today when Denise was giving her presentation, you know, we all take for granted we know what the rules are until we actually look at them and by gosh, there's something there I hadn't seen before. Well, the same was true as I put together my notes for today's seminar. What I wanted to provide first as a general overall rule that you all know is that with regard to injuries that result from motor vehicle accidents, no-fault coverage is primary, with one major exception, and this is where we talk about, again, factors that can influence the payment of no-fault benefits. And that exception is if the injury is a result of a work-related accident. In that case, then, workers' compensation benefits are primary, but they're not exclusive. So there still is some interplay between the workers' compensation payment scheme and no-fault. Minnesota Statute 65B.61 Subdivision 1 provides that primary status to the workers' compensation benefits. And again, mentions that the case law and what's developed is that it's primary, it's not exclusive. As I reviewed Subdivision 1, there was an issue that came up, and I didn't include the language in my outline, but the entire provision of Subdivision 1 ends with the right for a insured to ask for a rebate if they are in a work-related motor vehicle accident and are receiving workers' compensation benefits. And as I sit and look at all the experienced litigators out there, many plaintiffs' attorneys, I'm just curious if anyone has ever had that happen where they've requested a rebate for no-fault benefits premiums. Is that something that happens in practice? I'm a defense attorney, so I don't know. Has anyone actually exercised that right to a rebate, at least that's in this room?
No one has ever exercised it.
I think you should give it a shot.
Man, you let us know how that's...
Yeah. But did you realize it was there? I guess I didn't until I took a look at that statute. But let's talk about what happens when a workers' compensation carrier denies medical expense benefits or denies the claim. Because as in the no-fault world, the workers' compensation carriers will send the injured party out for an independent medical examination, and oftentimes it ends up in a discontinuance of benefits. While those benefits, those workers' compensation benefits are primary, as I mentioned, they're not exclusive. So once the workers' compensation carrier denies that claim, the no-fault carrier must adjust or medically manage the claims that are submitted to it. And as a result, if payments are made, the no-fault insurer can then intervene in the workers' compensation action, and I'll discuss intervention in a bit. But a no-fault insurer does have to respond to no-fault claims made if there has been a denial of the workers' compensation claim. The same is true for income loss benefits. If there's a denial, if the denial includes, as it usually does, any additional disability benefits, then again, the no-fault carrier must step up and adjust the claim, subject again to the intervention. While I primarily practice in the area of defense, every now and then I have a plaintiff's case or two, and I had one recently, or still have one, where my client was injured in a work-related motor vehicle accident. And in discussions with the workers' compensation attorney, it was pretty clear that that workers' compensation attorney, who didn't do personal injury as well, was unaware that the injured party can still make a claim for, additional claim for income loss benefits under their no-fault policy. As many of you know, in the work comp world, an injured party is entitled to 2/3 or 67% of their average weekly wage. In the no-fault world, the statute provides that the no-fault insurer should pay 85% of the present and future income loss up to the maximum of $500 a week. So there's that percentage difference between what the workers' compensation carrier pays and what the no-fault insurer pays, the 67% and the 85%. So it's that difference that then can be submitted to the no-fault insurer. And can be a pretty significant amount. In the example I gave, it was not. It was for someone who was a little lower paid employee. But the example I have is injured party's weekly wage is $500. If there had not been a work-related accident, that injured party would be entitled to 85% of that, or $425 from his no-fault carrier or insurer. But it was a work-related accident, so instead of the $425, that injured party is receiving 67% or $335. So that injured party can submit the difference to the no-fault insurer, in this case resulting in an additional payment of $90 per week. So it's something to keep in mind if you've got handling a work-related motor vehicle accident. In the world of intervention, too, and we'll talk about it, the specifics of that later, sometimes the no-fault carrier will include all of the income loss they've paid in the intervention claim, but they really can't. They can't intervene for benefits that they would pay regardless of what happened with a work-related accident. So in my example, that $90 a week would not be appropriate to insert in an intervention claim. But that's, again, you know, you've got those extra benefits through the no-fault policy if you are dealing with a work-related injury. Again, what if the work comp carrier denies the income loss claim in its entirety? Then you submit the whole kit and caboodle to the no-fault insurer, and if it's appropriately supported, then the insured is entitled to the $425 a week in my example. What about the situation where a injured party, their workers' compensation benefits have been denied, they go through a hearing, and they're unsuccessful in the hearing? The case cited on page 2 of my materials, the Kleinfelter case, indicates that even in that situation, the no-fault insurers, the claim for no-fault benefits can survive. And the reason for that is the Kleinfelter court took a look at the factors to establish collateral estoppel and determined that since the issues are not identical in a claim for workers' compensation benefits and a no-fault claim, that collateral estoppel did not apply. And so in that situation, even if an injured party loses their workers' compensation hearing, they are entitled to bring a claim for no-fault benefits. What about a voluntary settlement, though, which is how most of the claims are resolved, from what I understand? In a voluntary settlement situation, a subsequent no-fault claim would likely be prohibited because those settlements usually include future medical and settlement of the medical. So the Uterman case cited on page 2 stands for the proposition that after a voluntary settlement, a no-fault claim is not appropriate. When you've got an injured party who might be entitled to replacement service benefits and their injuries occurred in a work-related setting, you can submit a claim for replacement services, either a traditional replacement services claim or a primary homemaker replacement services claim. It doesn't matter, any sort of no-fault claim you have. Those benefits are not available through the workers' compensation system, so the no-fault carrier would have to reply to that sort of claim. So that's another thing to keep in mind when you've got dealing with a workers' compensation motor vehicle accident, a work-related motor vehicle accident. Any questions on the workers' compensation piece? I've also got some language when we talk about, okay, what's the law that impacts the payment of no-fault benefits? We've got prior injuries. You as arbitrators, I'm sure, hear the arguments often, probably every other hearing that you have, on how do you handle prior injuries. And before 2000 and 2001, it was really a mixed bag of how prior injuries were dealt with in the no-fault system. But in 2000 and 2001, the Pasusta and Scheibel decisions were issued. And I'll start with Pasusta. Pasusta addresses a situation where the prior accident was not related to a motor vehicle. In Pasusta, the claimant fell off a horse and she had injuries from that fall for which she was receiving treatment. And then she was injured in a motor vehicle accident. And the court in that Pasusta case said that the no-fault carrier, no-fault insurer, was obligated only for the treatment that stemmed from the motor vehicle accident. It was, again, interesting as I was preparing my notes for today's seminar. I have always argued that Pasusta established traditional principles of apportionment if the prior accident was not motor vehicle. But really, when you review the Pasusta decision, they do not use the term apportionment, and in fact, they discourage the use of the term apportionment, and it's just a matter of looking at, were the benefits at issue, whether they're medical expenses or income loss, were they causally related to the motor vehicle accident? And so that's really the focus when you look at the situation where you have a prior injury, and the prior injury is not motor vehicle accident related. Scheibel addresses the two-accident situation, motor vehicle accident situation. And what Scheibel determines is that if you've got sets forth is that if you've got two motor vehicle accidents and the second accident plays any role whatsoever, and I think in Scheibel there was a factual determination that the second accident resulted in 15%, or the treatment was related 15% to the second accident, whatever the percentage, as long as it's some percentage is related to the second accident, it's 100% payable off of the second accident. Once the second accident policy is exhausted, then the injured party can go back to the first accident policy, but then it's payable only to the extent that the treatment at issue is related to that first accident. So those are the two cases that address prior injuries. And any comments on that? I know that does come up quite a bit in your practice as arbitrators. Any unusual issues that you've addressed or faced?
Cindy, are there any, excuse me, are there any chat comments regarding the topic covered already?
There is one. I think it's a duplicate, but what about the need to determine facts such as reasonableness or necessity if there's a settlement of the claim? Do we just deny it if it comes out of that claim, of the workers' compensation claim that has been settled?
Well, I would imagine did everyone hear that question from the, yeah, okay. So if I understand the question correctly, I would imagine that it probably wouldn't get to the arbitrator that if there was a settlement of the workers' compensation claim that the insurer may opt to bring a motion in district court to prohibit the arbitration from going forward based on the settlement of the workers' compensation claim. But if it does, for one reason or another, go to arbitration, at that point, I think as the arbitrator in the no-fault setting, you would apply what you usually do. You would make the factual determinations of the reasonableness of the expenses and the necessity of the treatment. And as an arbitrator, it's not within your realm to decide legal issues. So if that sort of situation would come to you, you would make the usual factual determinations and proceed from there. And if a party believes that it shouldn't have been before you in the first place, they can bring a motion to vacate. I guess that's how I would see that playing out. Any other comments on that?
Yeah, I think once you've got the case and you're making factual determinations unless there's an order prohibiting you from proceeding. That's exactly what should happen.
I would imagine, as I mentioned, that the insurer will likely bring some sort of motion to dismiss the arbitration, but if not, and if it's before you, that's how I would recommend you.
I am curious how often that happens, that you actually get motions to dismiss these arbitrations, because I see a lot of them coming up they bring them to me. So I'm just curious about that. Anybody experience that situation? Jim? Anyone else?
I'm perplexed by that practice, quite frankly, because, certainly you have the option to bring a motion in district court to even, once a petition is filed, to address and have a legal determination on whether it should go forward. Because it should not be, a legal issue is not before the no-fault arbitrator, but if it's there, you have to decide it, subject then to one of the parties bringing a motion to vacate on the basis you exceeded your powers.
So I guess we're going to be making all these factual determinations and see if they do it after the fact. Huh?
Right, and I think that's what, as an arbitrator, you're required to do. What about, I'm going to move on to topic 3, and I will stop, go ahead, Jim.
Suzanne, I had a question for you on Scheibel.
Yes.
Suppose your doctor does not apportion a percentage.
Well, I don't know if there's a no-fault claim case that addresses it, but then you might have to fall back to the law in apportionment in bodily injury cases, and let me know if I'm correct on this, but I think it's for the defense then to parcel out which is which, and I think that would apply then to the no-fault claim as well. Any thoughts on that? And before I go on, thank you. The question was, in a Scheibel situation, if the claimant's doctor has not issued a report setting forth what accident caused the need for treatment, what should, what's the obligation in that case?
I think you're going to have some trouble. I think if the accident you're in there bringing the claim for is the one that you're supposed to be there for. And it's an evidentiary problem, I think. Your doctor needs to get on board here.
Well, so many of the petitions in a two-accident case will have both accidents. So as a no-fault arbitrator, you've got both accidents before you. And do we go back to our discussion this morning that if you can determine that, if the arbitrator can make a determination based on the medical records that at least 1% is from the second accident, I guess they can then, it's payable 100% off that accident.
Well, I'm thinking in the context of the second accident that as long as it's related to the second accident, you're going to get it covered 100%. But if you're coming in on the first accident,
right,
that's the issue. You need to have your doctor on board to say your first accident is what I'm treating you for now.
But practically speaking, not all doctors cooperate. I think we're aware of that.
We know that.
And it might not be that the doctor can't figure it out so much as they're not willing to state it. And so as an arbitrator, if there's evidence that helps you identify that, there's some portion of it that you can see is related and the defense hasn't offered you any information on how to apportion that you can base your decision on the other evidence presented, deciphering the records and testimony.
Certainly the better practice would be, and that's where we see a lot of the arbitrations is on the first accident, that try to get your doctor to say, oh, we're back to the first accident, because that's where it gets a little tough. If you pay 20 off the second accident, then you're trying to go back to the prior accident. You really should have a doctor's decision.
As an arbitrator, I've seen a number of times where claimants come to me and somebody had been injured in an accident, they were treating in a chiropractic clinic, and just continued to receive chiropractic treatment, sometimes not even mentioning the second accident. And they're there to try to get those bills paid under the policy for the second accident. The defense has come in and taken an IME that says this is all related to pre-existing. There's no evidence that it was aggravated by the second accident. And the claimant's there with no report from the doctor In my experience, I've balanced the evidence, and the defense has presented evidence that it was not caused by the second accident. The plaintiff has provided no opinion whatsoever, just simply a continuation of the medical. And I don't think it's appropriate for an arbitrator to try to make a medical determination of, well, gee, maybe probably died. I guess the evidence from the claimant says that it's aggravated, but I feel like if the defense presented the evidence that it had nothing to do with the second accident, and there's a complete absence of evidence that it was caused or exited by the second accident, I don't think we can just jump in and make that medical determination.
But I think,
let me just repeat the question, and then I'll let you. I'll try to summarize it, but the question was, in the situation where the injured party is receiving chiropractic treatment from first accident and then continues to treat and doesn't mention the second accident, there's the arbitration, and the claimant does not submit a report from the doctor indicating any of the continuing treatment is related to the second accident. How does an arbitrator deal with that? And the comment that accompanied the question was, it would be difficult for the arbitrator, it should be difficult, is it the arbitrator's job to parcel out the evidence when there's been no evidence other than perhaps an IME from the insurance company that would apportion it?
Well, I think that's crucial, is that defense has presented evidence that it wasn't for
Clarification was that it was the IME issue on behalf of the insurance company said it was not related to the second accident. How do you deal with that as an arbitrator?
and I think that that's consistent with what I had already said, that if the defense hadn't provided any evidence to support any sort of apportionment, or in that example that it was completely unrelated to the second. If there's not a report in support either way, that you could base your decision on the evidence if the evidence would support a decision. You know, again, it's really a weight of evidence.
The question that I have is, I'm assuming, number one, you're going in on the second accident only, that the arbitration was not filed where they filed for both dates of loss. Because I get a lot of, when I've seen Scheibel, a lot of times they're putting both accidents together in the same case. And so, in that context, you can still award it, I'm assuming, maybe on the first. But the real issue that if the IME is saying it's not due to the second, I'm presuming they're saying that it's due to the first. Maybe not, because it's a continuation of the same is what I'm hearing.
Yeah, but they may have been treating for 6 years with that, and their policy is exhausted, or
So now we're just,
in a car accident.
so now we're in just on the second accident. And this is where you get into trouble. This is why I'm saying you're in trouble. And the real question for me, I think, is, yeah, you do have to look at, has the claimant met their shifted burden of proof? And in that context, is there something in the medical records that the claimant can hang their hat on? Is there something that the claimant testified to that the claimant can hang their hat on? Because I don't think you're making the medical determination, you're making a causal relationship determination. And leave medical decisions to doctors, but we make factual determinations as to cause, reasonableness, and necessity. And I think if there's something in the records, you know, you got to take a look at that. But I come back to it's a slippery slope, and you've created some trouble if the doctor isn't there for you.
I'm going to move on to heading number 3 of the factors that can influence payment of no-fault benefits. And we'll talk about Stout, the idea, the situation where private insurer, health insurer, pays some medical expenses that arose out of a motor vehicle accident. And why don't we use the example of someone's injured in an accident, has to have surgery, $10,000 worth of surgery bills to Twin Cities Orthopedics, and they have their health insurance that pays $4,000, and Twin Cities Orthopedics says, okay, that's sufficient and you don't owe us a dime. Under the Stout decision, that what Stout indicates is that For no-fault purposes, the loss is the entire $10,000 bill. And in Stout, what the insurer argued was, first of all, why should that be? Because there's no loss to the insured. In other words, the insured doesn't owe Twin Cities Orthopedics a dime anymore. It's been paid by their private health insurer. And in response to that argument, the claimant argued, wait a minute, that's a contractual obligation between myself and my private health insurer, and then the private health insurer's obligation or contractual arrangement with Twin Cities Orthopedics, whatever that may be, just using them as an example. And so the no-fault carrier shouldn't get the advantage of or the benefit of those separate contractual obligations. And that's what the Supreme Court decided in Stout. And so in the situation I gave, that injured party would be able to submit $10,000, that $10,000 surgery bill, in the no-fault arbitration, and the no-fault insurer, if it's determined to be reasonable expenses for necessary medical, the no-fault insurer would be required to pay the $10,000. So that is Stout. In the way the world works now, and when doing defense work, you're often talking to people outside of the state of Minnesota about Minnesota laws, and trying to explain Stout to claim representatives can be difficult. But that is the rationale behind the Stout decision, and the Supreme Court did side with the claimant in that case that the insurer should not have the benefit of those other contractual contracts. So that's how we deal with that gap in Stout. Now, with regard to Social Security benefits, that comes up quite often where someone may already be receiving Social Security benefits for a physical impairment, and then they happen to be injured in a motor vehicle accident. In that situation, the argument would be, wait a minute, the claimant already is unable to work. That's been determined by the Social Security Administration. And I haven't looked at the standard recently, but the standard used to be to receive Social Security benefits, you had to show that you were unable to engage in any substantial employment activity. So from the standpoint of the no-fault insurer, they may say, why do we owe income loss? Then you've already been receiving Social Security disability benefits. What the Deming case on page 3 of my materials indicated was that because the No-Fault Act generally does not allow for the coordination of benefits, that you cannot offset no-fault benefits by any Social Security disability that's being received.
Would that be the same if the claimant comes in and they've been receiving short-term disability from a private insurer?
Well, there's really not a good answer to that question. It kind of falls into that next category of sick leave. You know, we all look at sick leave, short-term disability, which is a biggie, and there's really not a no-fault case that addresses that. There's one, the Hessian case that I've cited in my materials deals with sick leave, and the reason it's cited is that it seems to adopt the idea that if an injured party is receiving sick leave benefits after being injured in a motor vehicle accident, that they're allowed to also receive no-fault benefits if the sick leave is from a accumulated pool. In other words, if your sick leave is based on you get 1 day for every 2 weeks you work or whatever it may be, 1 day for every month you work, and you get to earn your sick leave and you have to deplete it because you're injured in an accident, then you're not required to offset those sick leave benefits, and you are entitled to your no-fault benefits on top of that. So the issue in the arbitration usually is it's a depletable sick leave, and that's usually pretty easy to figure out.
So is that more of a reimbursement of that loss that you had to use your sick leave?
Right. You have a loss because you've depleted your sick leave. But like if you end up in a situation where regardless if you're there 1 day or 6 months, you get 5 days of PTO a year, then the insurer would have the argument that gets offset. It's not depletable. It's not something you had to earn. You just got it. Now, to get to the short-term disability issue raised by John, there really isn't a case yet on that. There's what's usually applied are the cases that come up in the liability world and in tort claims. And the same notion, I believe, applies, that if it's a short-term disability policy that you have paid premiums for, you take a look at that, and if that's the case, then the claimant has the argument that there should be no offset for those benefits. I don't know if anyone's had any other different arguments, or if there's a case that I'm not aware of out there on short-term disability, but that generally is kind of the same analysis as you use for collateral source. You take a look if there are premiums paid for that benefit. But that is still an open area. Now, item number 4, it addresses situations where a no-fault carrier, no-fault insurer can recover some of the benefits that it's paid. It's very rare, because generally once we adopted the no-fault scheme in 1974, that was kind of the trade-off, is you get benefits no matter what if it's from your first-party no-fault coverage. However, there are a few exceptions, and we talked a little bit about work comp, and workers' compensation is one of those areas where the no-fault insurer can intervene in the employee, injured party, no-fault insured's workers' compensation claim. They can't bring a claim directly against the workers' compensation carrier. It has to be in an intervention in an existing claim. And it's like any other intervention. The no-fault insurer submits a petition to participate in to be a party in the workers' compensation proceedings. And when I represent insurers in intervention, usually it's sent out to a defense attorney because there's a lot at stake. They've paid $40,000 in no-fault benefits, and they want to try to recover it from the workers' compensation carrier. And usually there's some unusual issue, like is the injured party an employee or independent contractor, or were they in the course and scope? So there's usually some other issue that makes that claim a little different. Sometimes I'll get a little resistance from the insured attorney because they're not used to hearing from interveners, but it is rare. But if it's that kind of claim, I think that the no-fault insurer has the right to participate in the workers' compensation, certainly at least monitor it to try to recover some of the benefits they've paid from the workers' compensation carrier. There was a very interesting case, again, talking about situations that I really wasn't aware of, even after looking at the No-Fault Act for all these years. The Raymond case on page 3 of my materials, the unpublished Court of Appeals decision, was really fascinating to look through. And the reason I pulled out that Raymond decision to look at it was because in that case, the no-fault insurer was allowed to actually sue the insured. Very, very rare to recover no-fault benefits. But it was a very unusual fact situation because Ms. Raymond had a knee, work-related knee injury. She was on her way to the hospital for treatment when she had a motor vehicle accident. The workers' compensation carrier denied her claim on the basis she took a detour on the way to the hospital. Maybe she went through a drive-through or something. But anyway, she went through a detour on her way to the hospital, so they argued it was not an injury that arose in the course and scope of her employment. So she files a workers' compensation claim to challenge that, and then she also files for no-fault benefits. The no-fault carrier pays $10,000 before they realize, hey, wait a minute, there's a workers' compensation claim here. So then they intervene in the workers' compensation action. That matter is settled. And as part of the settlement, it includes medical expenses, so Allied in that case was reimbursed their $10,000 they'd paid, but the settlement also included some future medical. What happened then is Ms. Raymond filed for arbitration for her no-fault benefits. So she went to a hearing and was awarded another $10,000 in no-fault benefits.
Somebody didn't bring a motion.
Yeah, don't even bring emotion. And at that point, Allied said, wait a minute. They brought something post-hearing, and they said that based on Minnesota Statute Section 65B.54, Subdivision 3, we can sue Ms. Raymond to recover that second $10,000 that was awarded by the arbitrator. And what Subdivision 3 says is that if the obligor, in this case Allied, is entitled to reimbursement from the person obligated to make the payment, arguably the workers' compensation carrier, or from the claimant who actually receives the payment. In those situations, they can bring a direct claim against the insured. So in that case, poor Ms. Raymond did have to surrender the $10,000 that she was awarded in the no-fault arbitration. So very limited fact situation, but first time I saw that a no-fault carrier could bring a direct action.
I wonder if that would include a fee forfeiture, too.
Yeah, possibly. There was discussion in the case about interest, too. You know, there was
really?
interest awarded, so what do you do
Wow.
with that? But I think she was entitled to keep that.
Well, she gets something.
Right. The other area, and again, this has been something for as many years as I've been looking at the no-fault statute and the type of work I do, it's only been within the last 5 to 10 years that I've been doing indemnity work. And Minnesota, when we talk about when can a no-fault insurer recover benefits it's paid, another exception in addition to workers' compensation is if the vehicle is, or if the accident is caused by a commercial vehicle. And the law behind that makes a whole lot of sense because trucks, semis on the roadways cause more damage. They're just bigger. They cause more damage than passenger vehicles. So the legislature determined that no-fault insurers should be able to bring indemnity claims against the residual liability carriers for these commercial vehicles. So at 65B.53, Subdivision 1 is the indemnity statute. And that's a dollar-for-dollar recovery for the no-fault insurer if the at-fault vehicle is at least 5,500 pounds curb weight, and if that commercial vehicle is at fault, in other words, caused the accident, and if the treatment is deemed to be related to the accident, then the no-fault insurer is entitled to recover from the commercial insurer, the insurer for the truck. And oftentimes, I think claim representatives handle those type of arbitrations. They're handled through the statute. Subdivision 3 of that statute says that the Department of Commerce should establish rules to arbitrate these indemnity claims. And the Department of Commerce did issue a bulletin appointing the Arbitration Forums, Inc., the same outfit that handles property damage claims between insurers, to also handle indemnity claims. And so that's where these indemnity claims are heard. I think that when defense counsel is involved in cases, it's usually because there are issues that are unusual, like statute of limitations. There might be an issue as to whether the commercial vehicle is actually a commercial vehicle, 5,500 curb weight. It's amazing. There are websites out there, if you put a VIN in, that can tell you what the curb weight of a vehicle is, but they're not consistent. So that can be a factual issue. I know, it sounds crazy, but you can get different curb weights. The statute and the case law also says that, okay, 5,500 curb weight, but if it's a plumbing vehicle, for instance, and they've got extra equipment in it, you can't count that weight. So some of that, it gets to be, is it really a commercial vehicle? And is it 5,500 pounds of curb weight? So there are some interesting issues that can come into play. A lot of the time, what happens is insurers don't understand the indemnity, the commercial insurers, and so they'll respond to a claim by saying, we're not signatories to intercompany arbitration, which is the arbitration for property damage, so we don't have to respond to your indemnity claim, no-fault insurer, and that's not right. Because of the statute and the rules promulgated by the Department of Commerce, every commercial insurer, whether they're a signatory to intercompany arbitration have to participate in arbitration through Arbitration Forms, Inc. to determine this indemnity claim. So all of this, how does this impact the no-fault world and the payments? What I can tell you is that sometimes in defending or bringing these actions, the commercial carriers will say, gee, the no-fault insurer didn't really medically manage this claim well because they knew they were going to get money back from the liability carrier for the truck. And so sometimes I don't see that in practice happening, but I can see that there's a potential there that you might wonder, well, why isn't the no-fault insurer sending this party out for an IME? Well, it may be because they realize and they've put the commercial carrier on notice that they're going to bring an indemnity claim. It's a dangerous approach, I think, from the no-fault insurer's standpoint if they don't do that, because it is very legitimate for the Arbitration Forms, Inc. to partially award a claim on that basis that it was not medically managed appropriately. But that might be sometimes why if you're scratching your head wondering, well, why are they not sending this injured party out for an IME? That could be one of the reasons. The same is true in the workers' compensation world when we talk about how do all these other payment schemes impact no-fault, the payment of no-fault benefits. That can be a factor, too. Again, it's dangerous, I think. I think the no-fault insurer should adjust and medically manage their own claim regardless of whether there's workers' compensation out there. But that could be a reason why you're not seeing, plaintiff's attorney is not seeing an IME right away. So that's just a couple different ways that the insurer can recover benefits that are paid. The last area has to do with subrogation claims. I've handled a couple of those over the years, probably more than a handful, but they're tough. Under the No-Fault Act, in addition to indemnity against commercial insurers, a no-fault insurer can recover by way of subrogation if the motor vehicle accident is caused because of the negligence other than in the maintenance or use of a motor vehicle. So an example, injured parties gassing up at a gas station, it's icy conditions and they slip and fall. That would be negligence outside of the maintenance and use of a motor vehicle. It's the icy conditions that cause the slip and fall. I've had three cow on the road cases where the accident is caused because there's a cow on the road. And then we take a look at it and can bring a subrogation claim, not against the owner of the cow, but we can step into the shoes and assert it with the injured party, the no-fault insured. So that's where it gets to be a sticky wicket, because in the cases I cite, the whole purpose of the subrogation is to avoid double recovery. So that's why the no-fault insurer steps into the shoes of the injured party. However, most injured parties are represented by pretty savvy attorneys who realize that, okay, I can settle my claim with the owner of the cow, with the gas station, by putting in my settlement agreement, we're settling everything but my no-fault claim. We're settling for everything but my past medical expenses. So it's a way that the subrogation claims are defeated. So that's why they're very, very difficult for a no-fault insurer to recover on. But they're out there, and the No-Fault Act does.
So it's a neg agreement for no fault.
Exactly. I've tried several different ways to try to make it attractive for the plaintiff's attorney not to do that and to fashion some sort of incentive for them to include the no-fault benefits that have been paid in the settlement. But quite frankly, from most attorneys will say, well, we can just deal with a Milbrandt settlement, and that defeats the subrogation claim then. Any questions on these topics? There were a couple. I think we've got a few minutes left. One thing I wanted to point out, because it's come up tangentially, what about these legal issues? What if, I talked about Stout. What if I'm sitting at an arbitration and the respondent saying, hey, wait a minute, I'll use my example again. Twin Cities orthopedic was paid totally, and there's no loss here. So deny that bill totally, arbitrator. What are the obligations of the arbitrator when it's a legal issue? It's been determined by the Supreme Court. Well, in that case, we all know that arbitrators are to decide the factual issues, and district courts in no-fault proceedings are to decide the legal issues. However, you can't rule in a vacuum. You know, there's sometimes you just have to apply the law to the facts. What happens in those situations then is you can, if one party is aggrieved and feels that you've applied the law incorrectly, and the example I gave, the claimant can say, you're wrong, arbitrator, that's stout. Well, the claimant then would need to go to court, to district court, and bring a motion to vacate that on the basis that the arbitrator exceeded her powers when finding that there was no loss in that stout situation. So that's the remedy. But, you know, as you handle these motions to vacate, every time you look at it, there is some element of law that you have to apply. You are the factual finder, but you still have this No-Fault Act and all the cases that are promulgated under it, and sometimes nobody disagrees. Most of the time they don't with whatever law you had to apply to get to that result. But if they do, that's when the motion to vacate comes into play.
Suzanne, throw a hodgepodge question in.
All right. Are you sure it's not a smorgasbord or a potpourri question?
This could be a new one. It's a smorgasbord question. 62Q.
Ooh.
Western National versus Wynn, Court of Appeals applied 62Q and 65B54, the electronic transmission standards, as well as the submission by the healthcare provider. And the Supreme Court recently divided 3-3 and basically affirms the Court of Appeals. Question I'm wondering is, what are we looking for as arbitrators when it comes to 62Q issues now, when we get to the hearing?
Well, I'll open it up, but it's got to be raised. Don't you think that's the first element? So if it's raised, it's going to be raised by the respondent, and the respondent then should set forth the evidence that either the electronic submission wasn't made, it wasn't made timely. The claimant can then talk about a disruption in the billing service system. So it's got to be brought up, and I think there has to be evidence for the arbitrator to decide.
I recently, shortly after the Supreme Court decision came out, 3-3, with no opinion, got confronted with 62Q, and the question that I raised, there wasn't a single piece of evidence presented to me as to whether or not the providers actually submitted the bills, whether or not the providers knew who the insurer was. And then later, I kept the record open to get more information, and then got provided information that the claimant had been submitting the bills to their insurance agent.
Oh.
So I think in a 62Q setting, I think it's incumbent upon the insurance company, if they're going to be raising this, it comes across to me as more of a defense than anything else, that the insurer better provide us some evidence in the hearing as to who submits the bills. And if they didn't submit the bills, did they know who the proper insurer was? And how were the bills submitted? Because there are the electronic transmission standards, as I understand it, not every insurer is set up for electronic submission of bills. So if they're going to claim electronic submission, I think they're going to have to also establish that particular insurer is one of the providers that requires electronic submission of bills.
I guess I'd agree. Again, your award has to be based on evidence. I had a situation where the respondent's attorney was arguing a failure to submit electronically. well, we left the record open for additional evidence. Well, it turns out that the adjuster had instructed the provider to fax the claim. The attorney, I'm sure, is making the argument that they think is available to them, but it was inconsistent with what their own client, the adjuster, had asked the provider to do. The provider is complying with what the adjuster specifically requested. And in that situation, the evidence ultimately supported that electronic submission was not mandated because of the way that they had been previously instructed. So again, that evidence would have to be provided for you to really be able to make a ruling.
With a waiver or estoppel kind of a situation.
Right.
Hand in the back.
Do we have a definition of what electronic is? No electronic is
62J.
Question.
What is the standard for submitting electronically? Is that right? How do you do it? Is it email? Is there an actual program that it has to go through?
Would it have to be a HICPA?
The HICPA itemized bill, that's a good question. I believe 65B.54 sub 3 references 62J. I believe that's the provision at site. I haven't read 62J. And frankly, I kind of think if anyone listened to the arguments at the Supreme Court on this, it's kind of a mess that the legislature has created. But I don't know definitively what is required to do. Is it an email with an itemized bill, or a bill that was mailed by the provider to the claimant, and then the claimant or the attorney or somebody just emails it to the adjuster? I don't know. I don't know what it is. And what do you do in the situation where it's one of the insurance companies that doesn't do electronic submissions at all? So I think those are issues that, maybe smarter minds than ours are going to be able to address in the future, but I suspect it's going to become more of an issue in these no-fault arbitrations.
And I also suspect, and I don't know if there's any activity in the legislature now, I don't know if either of you do, but
I haven't heard it.
I would imagine eventually that's where this would be resolved, is in the legislature. Any other questions or any questions online?
Cindy, can you open up the line?
Yeah, I will. There is one question that was received by chat, and you can answer that while I'm opening the lines. And someone asked if they will receive the materials that the speakers have referred to.
Yes, so I sent that out by email yesterday to all the folks on the phone. I can resend all that stuff either later today or tomorrow. But otherwise, please look for an email from me sent yesterday afternoon with materials. And there are materials for the first and second seminar only.
And the phone lines are now open.
Any questions from anyone on the phone? All right, then we are going to conclude the second seminar here. We will meet back in 15 minutes. And again, those of you who are going to be attending online, the third seminar, you'll need to use the link and code to get back in for seminar 3.